Good afternoon, and welcome to the Senate workshop on the day-to-day working application and interpretation of the university legislation. We have a special guest speaker here today. This is meant to be an interactive session, so Patrick is going to invite you to engage with him in a dialogue, and we'll go as long as there is interest, but in interest of people's the interest of the coffee and various other things, we'll give you a break at about 5:20 so that you can have some coffee and perhaps chat for a few moments on an informal basis. I'd also like to take this opportunity to welcome back our former Vice President Academic and Provost Judith McGilvery, who is joining us today. She's working on her doctorate. Welcome, Judith. John McKendry, our president, set this up and invited Patrick Gilligan Hackett to come and speak with us and to engage with us. I'll give you a short biography on Patrick, and then I'll give him the floor, and he'll begin his presentation. He has a whole set of notes which you have, or you should have, and if you don't have them, you can get them. They're just outside the door, and that way you don't have to take notes. He has done those for you. Patrick Gilligan Hackett practices in the areas of administrative employment, human rights, and labor law, including related civil litigation. He represents major public and private sector employers, including 4 universities on a regular basis and 2 universities on an occasional basis. He has acted as counsel at all levels of both the British Columbia and federal court systems and in proceedings before various administrative tribunals, including the Real Estate Council of British Columbia, the British Columbia Labour Relations Board, the British Columbia Human Rights Tribunal, and numerous arbitrations. Mr. Gilligan Hackett has been a speaker at numerous conferences, has published a number of papers on topics related to his practice, and is co-author of the chapter on faculty employment in a pending textbook on Canadian university law. It's going to be a page-turner. He is a past president of the Canadian Association of University Solicitors. Mr. Gilligan Hackett was called to the bar of British Columbia in 1984 after obtaining his law degree at Osgoode Hall Law School and his Bachelor of Arts degree at the University of Victoria. Please join me in welcoming Patrick Gilligan Hackett.
Over the years, as I've done sessions like this, I've come firmly to the conclusion that they much better serve the participants as a dialogue than as a lecture. And so I always encourage people who are attending an occasion on which I'm speaking to ask questions, make points, raise issues. I'm happy to discuss those freely, and as I say, I think they give a livelier and more interesting and more valuable result for the people who are involved in the speaking occasion. John McKendry asked me if I would speak to the Senate and also, I understand, to the board on the legal context within which university governance takes place. John, I think from my discussions with him, is very concerned during his presidency to try and optimize and enhance this area of Kwantlen's activity. And with that in mind, has asked me, as I say, to speak to both the Senate and the board on these issues. One of the challenges for a lawyer, and as Gordon indicated in his introduction, I act extensively for universities in British Columbia and have done so for many years. One of the challenges for lawyers who do my sort of work is that most issues of this type get resolved in a political rather than a legal context, a small p political context, or perhaps a better choice of words would be a governmental context. And as a result, there's a very limited amount of case law. You'll be surprised when we come to discuss the case law how recent some of the cases are. there's a very limited amount of case law to provide people who are engaged in trying to resolve the issues that naturally occur in any form of governance to understand and decide how those disputes should be resolved. So part of the goal today is to provide all of you with as informed a framework, as informed a legal framework as possible, so that as you go forward and discharge your very important responsibilities to Kwantlen as senators, you have a little bit more to draw on, a more principled basis to draw on when you deal with what are inevitably going to be occasions of disagreement, potentially dispute, situations in which people passionately and sincerely hold different perspectives on important issues. The reason the legal perspective is important is because universities and the elements in universities that constitute their government are the product of statute. What happens in a university, if it leads to a significant enough dispute, ends up in the courts. So it's not in that sense a pure political process where voters decide who's right and who's wrong at periodic intervals and get rid of the people they don't like. Here, if there's a dispute and it can't be resolved through what I've called the small p political or governmental processes which are internal to an institution, it ends up in the courts. And understanding what the courts might do with it and how they see the issues should assist in achieving what I'm certain is everyone's paramount goal, which is optimal governance for Kwantlen. I say that it's all a product of law because while the historic roots of university governance are very deep, the current situation in British Columbia is that universities are continued and regulated by a statute of the legislature, the University Act. We'll talk in more detail about the Act and how it sets structures up and what the particular elements of those structures are a little bit further on. I wanted to begin, and I'm just here at the introduction, which is a couple of pages in the materials I prepared for you, with a comment that seems obvious and probably will be obvious to most of you, but has profound significance for the issues we're talking about today. And that's the fact that the University Act contemplates that university governance will be based on a bicameral model. The elements of the bicameral model are, of course, the Senate and the Board of Governors. Each of those bodies has a distinct area of authority and responsibility, and each of those bodies has a distinct set of powers associated with its authority and responsibility. There isn't a hierarchy as between the board and the Senate. It's a point that judges are at pains to make. There was a time in British Columbia, a much earlier version of the University Act, when if there was a dispute about the Senate's powers, the board made a binding decision. But that's a thing of the past now. And as a result, those who are members of the board have, as I say, an area of authority and responsibility and associated powers. Those who are members of the Senate are in the same position. That creates a potential for there to be disagreements, differences around important issues. And at least in my view, the Court of Appeal in this province and the courts elsewhere, when they've dealt with disputes arising in some sense from the bicameral model, expect governmental maturity, expect compromise, expect collegiality, expect that there will be an effort, a sincere good faith effort, to find a way through the difference. And we'll look a bit later in the talk at a case in Ontario which arose out of a long-term problem at Trent. And we'll see what happens when those sorts of collegial good faith resolutions don't occur and the sort of problems that that kind of dysfunction can create. Now, As I mentioned, there are two distinct elements to the governmental model, and the responsibility of the board under the University Act is quite clearly with what I'll call broadly the business operations of the university. The responsibility of the Senate is with the academic governance of the university. Those two things don't exist in silos, and the Act recognizes that there will be areas where decisions about business matters necessarily engage matters of academic governance. And as we'll see, the Act expects that the board will, in those circumstances, either take the advice of the Senate, doesn't necessarily have any legal obligation to follow it, but it will take the advice of the Senate. In other cases, it may only act with the approval of the Senate. And in still other cases, there will be an obligation on the Senate to give advice, as well as on the board to take advice. So the statute expects the kind of cooperation where there is an interaction or integration between the respective subject areas of the Senate's authority and the board's authority, that there will be interaction, collegiality, cooperation. The talk this afternoon really has three focal points, and they are to provide senators with, as I've indicated, a comprehensive overview of the legal foundations for the bicameral governance model, with an enhanced understanding of the role of the Senate at a special purpose teaching university, and an enhanced understanding of the role and responsibility of a senator at Kwantlen. Now, in commenting on those 3 points, I note that we're dealing with a Senate at a special purpose teaching university, and those of you who've looked at the University Act as part of your discharge of your responsibilities as a senator will have noticed that the Act, with the creation of the special purpose teaching universities, now has different sections dealing with the authority of the Senate at UBC, the authority of the Senates at UVic, UNBC, and SFU, and the Senates at special purpose teaching universities. And there are some real differences between the constituent elements of those sections. A large part of this, and it's funny, Judith and I were chatting briefly about this just before we began, a large part of this is very deeply rooted in the historical identity of universities. That identity has deep roots in the prototypical corporate structures which emerged in the Middle Ages. I don't propose to spend any great amount of time on them, but that's not without importance in a current setting. If one looks at the sort of offices that exist at a university, things like chancellors and vice chancellors, and although we don't use the term, the statute does, bursars and registrars. Those are not offices which are typical in a modern commercial corporation, but they are offices which are very typical, as I say, in the prototypical corporate bodies which began to emerge in the Middle Ages. Things like the Inns of Court in England, some of the medieval guilds, and so on. And the significance of that in terms of the modern university is that those were also collegial structures. They were designed to deal with the interactions between and the regulation of bodies of individuals who were motivated not in a narrow sense by commercial gain, but by some larger interest. In universities, it's typically characterized as the search for truth. And while it's easy in one sense to pay lip service to that or to be a little cynical about that, that is in fact at the core of the activity of universities. And so the activity is not commercial in nature, except in a secondary sense. It's first and foremost driven by larger ideals and larger objectives. And so the linkage, as I say, with those prototypical corporate structures that emerged in the Middle Ages is linked to the nature of the activity in which the university is engaged. And it influences to this day the sort of governmental structures which exist at a university. Now, some of the examples that I give are the emphasis on process at a university, particularly in connection with the admission of applicants to membership in the university and the appointment and promotion of the university's faculty members. When I get involved, as I do from time to time, in a tenure or promotion dispute, it's typically all about the process. It's not about in court or before an arbitrator whether the president's assessment of the research trajectory was substantively correct, because the court or the arbitrator has no way to judge that. It's about whether the process that led to the president's decision was the correct process. So unlike a commercial dispute where the court, or if there's an arbitrator, the arbitrator will be very much engaged with the substance of the dispute, focus at university is very much on process. And you see that as a lawyer, I'm a member of the Law Society, you see that in the Law Society's operations. As Gordon mentioned, I do some disciplinary prosecutions for the Real Estate Council. It's very process-oriented. Similarly, the establishment of faculties, which are often but not always divided into departments and schools, reflecting specialized academic interests, which are overseen by deans, reflects the type of prototypical corporate structures that I've mentioned already. The establishment or recognition of senior university offices, such as those of Chancellor, Vice Chancellor, Provost, Librarian, Bursar, and Registrar. It's like we're describing a monastery. The establishment of internal tribunals, which lawyers call domestic tribunals, to decide important issues. Again, a hallmark of these prototypical corporate structures and the forms in which they've evolved is that they will have domestic tribunals. They will regulate themselves. They won't turn as a first resort to somebody outside the corporate structure to make the decision. The recognition of convocation, the assembly of the members of the institution to witness one of its most important functions, which is to grant degrees of membership on newly arrived members. And finally, the legally recognized right of a university to grant degrees of membership to those who have completed a prescribed course of study. So all of this is reflective of a corporate structure which emerged, as I say, not for the purpose of commercial gain, but for the purpose of pursuing a larger ideal. Now, it's easy, despite their importance, to lose sight of the fact that these and similar structural and procedural elements lie at the core of a contemporary university. They're, in a sense, it's a word I like to use for something that surrounds us all the time, they're the university's wallpaper. They're just there. Many of you are members of Senate. You're just members of Senate. You probably don't think a lot about that, except if you're at something like this where it's put on the front burner. It's just there. But in fact, while they may be overlooked through familiarity, they play a core role, as I say, in understanding the nature of a university's legal identity. And so the link between the historical roots and the current university, the evolution of that link, tells you quite a lot about the way in which the legal structure of a university will operate and how it will exist. As I mentioned, in British Columbia, we're all, as lawyers like to say, creatures of statute. And so the statute that we're concerned with here, the statute of which the university is a creature, is the University Act. And each of the elements that I've discussed tends to be reflected in a discrete part of the Act. Part 2 recognizes the right of a university to grant degrees. That's why when the fraudsters get online and offer your master's from a program at Kwantlen, Kwantlen can actually do something about it, depending where they're located and how nimble they are with their website. But Kwantlen can do something about it, and that's because it's Kwantlen that has the legal right to grant degrees from Kwantlen. Part 3 recognizes that a university is a corporation that consists of designated components, and in the case of Kwantlen, those are a chancellor, convocation, a board, a senate, and the faculties. Each of those has a legal foundation for its establishment. For present purposes, obviously, we're concerned with the Senate and the board because they are at the core of the bicameral governance model. Part 6 of the Act establishes the board, provides for its composition and appointment or election, prescribes the term in office of its members, and grants the board its powers, including those powers which must be exercised in some form of collaboration with the Senate. Part 7 establishes the Senate, provides for its composition and appointment or election, prescribes the term in office of its members, grants the Senate its powers, including powers that must be exercised in collaboration with the board. Reference should also be made to Part 9, which allocates certain responsibilities for university elections to the Senate. Part 8 establishes the process by which faculties may be established and recognizes the role of both the board and Senate in this process. And I know from some work I've done for John recently that that's obviously been a fairly live issue with what I understand is the merger of a couple of your faculties into a single new faculty. And all of that, although it may or may not have been on your sight screens at the time, is a product of these powers and authorities that are granted to the Senate and the board in the legislation. In addition to recognizing the role of the Senate in the process of establishing and recognizing faculties, the Act recognizes the Senate's general supervisory role over an established faculty's operations. All of this, of course, in pursuit of and to support the Senate's role in academic governance. Part 10 recognizes and allocates a range of powers and duties to a university, so the university as a whole, as a corporate entity, with particular reference to the functions and duties of Kwantlen as a special purpose teaching university in section 47(1). And those functions and duties, in my view, provide an important context for the Senate's and the board's exercise of its powers. So I commend to those of you who are members of Senate some consideration of what the powers and duties of Kwantlen, as set out in Part 10, are. It's not a long section, but as I say, it's an important context for the exercise of the powers and duties of the Senate and of individual senators. Part 11 recognizes and allocates specific powers to the offices of the President and the Registrar. Will come the final of the 3 cases which I've put into the notes before you is a case that arose at UBC involving provisions in the faculty collective agreement at UBC, which the board, of course, had entered into as part of its powers, which trenched on the president's powers under the statute. And ultimately, it was held that the board had, or at least the arbitrator interpreting the provisions of the faculty agreement in question, had overridden the president's statutory powers and had no authority to do so, had no jurisdiction. That case is of importance, as we'll see when we come to look at it in a bit more detail, because it underlines that where the statute grants a body or an individual specific powers, they are the powers of that individual. It's not open to another body to interfere with them or take them away. That's an important principle. It guarantees the autonomy of the Senate, it guarantees the autonomy of the board, it guarantees, in the more limited circumstances where the president has power, the powers of the president. And the courts will, as we'll see, enforce those powers and enforce the autonomy that attaches to them. Now, as I mentioned earlier, there is relatively little case law interpreting and applying the Act in contexts which are relevant to our present topic. But the 3 cases that I did want to bring to your attention, and for those of you who find they have a surprising appetite for the minutiae of legal analysis and debate, all of these cases can easily be found online. You just go to in the case of BC, the BC Courts website, and search the decision. You've got the full style of cause there, and in the case of the Ontario case, it's the same approach, just on the Ontario case, Ontario Courts website, so they're easily found. The first one I wanted to deal with is the BC Court of Appeal decision in a case I'm calling UBC 2010, The style of cause is Faculty Association of the University of British Columbia and University of British Columbia. I call it UBC 2010 because, as you'll see, the same style of cause applies to the second of the BC cases we look at. So I've just called the second one UBC 27. Now, as I mentioned in paragraph 19, there was a specific context for the case before the Court of Appeal, and that was an arbitral decision declining jurisdiction over an apparent conflict between a Senate policy on student evaluations and provisions in the faculty's collective agreement regarding student evaluations. So you can see how that could happen. At UBC, the Senate had some years ago undertaken quite a comprehensive review of its mandate, its activities, and one of the things that they decided they should focus on more fully and carefully was quality of teaching. And having decided that, they then issued some policy on student evaluations of teaching. The faculty were not totally enthusiastic about the Senate's views of student evaluations and took the position that provisions which the board had agreed to in their collective agreement were A, paramount, or B, should at least be read to harmonize the Senate's policy and the faculty agreement faculty agreement provisions, or should be set aside altogether. So what that framed for the court, going back to some of my earlier comments, was who had the power here? The board, through what was its undoubted authority to enter into a collective agreement with the faculty, had negotiated some provisions around student evaluations. Faculty obviously thought those were okay, they'd negotiated them. The Senate, further to its mandate, had passed the policy dealing with student evaluations. The faculty didn't like that, so they challenged it at arbitration. And ultimately, as we'll see, the court said, Senate has the power to govern the university's academic affairs, not the board. And so when the board entered into these provisions in the faculty agreement, they were acting outside their authority. Now, it could be that they never would have been challenged and things probably would have just perked along without too much concern. It was, of course, when the Senate decided it was going to do something different that the problem crystallized. But the critical point for our discussion is that the board, despite its power to enter into a collective agreement, didn't have the power to negotiate student evaluation provisions with the faculty that conflicted with what the Senate wanted to do, because the Senate had the autonomous power to issue that policy, and as part of its mandate to govern the university's academic affairs, had the power to create a policy that would prevail over anything the board had done. The court discussed at some length, and this is part of the particular value to us, the context in which the arbitrator had undertaken his analysis of whether or not he had any jurisdiction under the faculty agreement, which is where the arbitrator got his jurisdiction from, to take the matter on. And so I've quoted a bit more than I sometimes would because, as I said earlier, there's so little case law, and this is the Court of Appeal of our province, so it's the law. Indeed, there was the Faculty Association at UBC, after they lost in the Court of Appeal, sought leave to appeal to the Supreme Court of Canada, and it was denied. So this is the definitive statement. And this is what the Court of Appeal had to say. I'm 2/3 of the way down page 4. The majority of board members are appointed by the Lieutenant Governor and Council. Section 19.2 of the Act provides that the Board of UBC is composed of 21 members, the Chancellor, the President, 11 persons appointed by the Lieutenant Governor and Council, 3 faculty members elected by faculty, 3 students elected by students, and 2 employees elected by employees. Pursuant to Section 27 of the Act, the Board is vested with the management, administration, and control of the property, revenue, business, and affairs of the university. It is the business arm of the university, and in that capacity has the power to appoint and remove senior officials and faculty on the recommendation of the president. The board's power to enter into the collective agreement on behalf of UBC is found in section 27(2)(s), which specifically gives the board the power to enter into agreements on behalf of the university. They go on, while the Senate, I'm speaking obviously, is broadly responsible for a university's academic affairs. This is what the Court of Appeal said. Unlike the board, the Senate's membership is composed primarily of elected faculty and students. The composition of the Senate is set forth in section 35.1 of the Act. The current Senate is composed of 90 members, made up of the Chancellor, the President, who is the chair, the academic vice president or equivalent, the deans of faculties, the chief librarian, the director of continuing education, 36 elected faculty, 18 elected students, 4 persons who are not faculty members elected by convocation, 1 member elected by the governing body of each affiliated college of the university, and additional members determined by the Senate. In terms of accountability, it is significant that elected faculty form a substantial component of Senate membership. Section 37 of the Act provides that the Senate is vested with the academic governance of the university and sets out the statutory responsibilities of the Senate in that regard. Though student evaluation of teachers is not expressly provided for in the powers granted to the Senate under the Act, it is accepted by the parties and the interveners that student evaluations properly fall under the Senate's power over academic governance. The Court of Appeal recognized that under the Act, in addition to areas of autonomous responsibility and power, the Board and the Senate also share areas of responsibility and power. In addition to the powers expressly granted to each of the Board and the Senate, the Act also provides for intersecting or overlapping powers between those two bodies. For example, in some instances, the Senate is empowered only to make recommendations to the Board, and in one instance, it requires Board approval of its actions. None of these intersecting or overlapping powers has been relied on by the parties as a significant factor in this analysis. Finally, the BCCA recognized that the university as a whole has powers and duties, and that the section conferring those powers and duties provides general guidance about the manner in which they are to be exercised. Part 10 of the Act deals with powers and duties of a university and states in section 46(1) that a university has the power and capacity of a natural person of full capacity. If any of you have ever incorporated a company in pursuit of other interests, you'll recognize that sort of phrasing. It's the phrasing that's used when a corporation is put together, and it's simply to confirm that the university or corporation has the same authority, autonomy, and ability as any one of us to conduct its affairs, to enter into agreements, and all the rest of it. One of the university's stated functions in section 47(2)(f), and I just note for you here, it should be noted that an equivalent subsection is not found in section 47.1, the provision of part 10 that applies to Kwantlen, is to generally promote and carry on the work of a university in all of its branches through the cooperative effort of the Board, Senate, and other constituent parts of the university. Thus, the Act contemplates cooperation between the Board and the Senate in carrying out the work of the university, but it does not provide for a tiebreaker or the equivalent of a paramountcy provision. If the exercise of powers by the Board and Senate respectively come into conflict as here, and then they comment on a provision of the Act that gives the Board the power to make a final determination with respect to disputes that might arise involving powers other than those of the Senate. At the same time, while there's no tiebreaker provision in a conflict between the Senate and the Board, there is, I think, a clear expectation among the judiciary that a Board and Senate will cooperate in the governance of a university. This is a further quote from the BC Court of Appeal. I agree with the arbitrator that while the structure of the Act and the allocation of powers between the Board and the Senate admit of the potential for operational conflict from time to time, the Act expressly sets out the areas in which the Board and Senate have separate powers and those where the powers are intersecting or overlapping. As Mr. Justice Sharp stated in Kolchiski, which is the Trent University case I mentioned, which is influential in the BC Court of Appeals reasoning, one would expect the board and Senate to cooperate in all areas of mutual interest. But ultimately, the power over academic governance is in the Senate, and the board is not entitled to interfere with its policymaking role in that regard by the terms of a collective agreement or otherwise. While I find some attraction in the double aspect approach to the problem referred to by Mr. Justice Sharp, I think it would present more problems in terms of practical application than it would solve. More importantly, I do not find support for that approach under this Act. There's a clear recognition, as I said earlier, of the autonomy of the board and the autonomy of the Senate within their respective areas of authority, and a recognition that there isn't, as the court calls it, a tiebreaker provision. If at the end of the day, the board within its area of responsibility makes a decision, it doesn't matter, provided any preconditions to the decision have been satisfied, that the Senate doesn't like it. And similarly, if the Senate makes a decision within its area of authority and the board doesn't like it, at the end of the day, it doesn't matter. The board is legally entitled to do so, the Senate is legally entitled to do so. Now, having said that, obviously we're talking about a governance model, not a disputation model, and hence my emphasis on the court's reference to the Ontario case and the expectation that there will be cooperation. Now, as I noted, Kolchiski plays an important role in the BC Court of Appeals analysis, and it's worth taking a look at it because it's a case where everything had gone wrong between the Senate and the board over many years. Particularly if you ever trouble to go and look at the decision itself, you'll see what's really a pretty sad history of dysfunction in the university's governance over many, many years. In Kolchiski, two faculty members, one of whom happened to be a senator, mounted a legal challenge to a decision by the board to consolidate Trent's operations and facilities on a single campus, with the result that certain other operations would be closed and their associated facilities sold off. Briefly, the situation was that in its early days, while the main campus was under construction, Trent had acquired a couple of temporary facilities in downtown, and those had evolved into, I'm going to call them loosely, colleges over a period of time. They'd come to have some sort of recognition, and I guess from the way it's described in the case, they were where the cool kids went. So there was a vested interest, it's fair to say, among those whose programs were being offered downtown and who had obviously enjoyed what was no doubt an appealing academic life around the existence of those institutions, in seeing them continue. The problem was that Trent was in a huge financial mess. Its infrastructure, it had been built in the 60s, its infrastructure was decaying badly. It was having trouble meeting the programming requirements for the students it had admitted. It was in serious trouble. There wasn't any debate about the reality of that financial trouble. The Ontario government had come along with a program which provided certain rationalizations of the university's finances took place, would provide quite substantial money for capital improvements. And the board was, to all appearances from the case, desperate to get its hands on that money. And so they had commissioned a task force which involved full representation, students, faculty, people in the community, the whole works were included. And the task force, in fact, had recommended that the downtown facilities be closed, the programs moved to the main campus, and the facilities that were now no longer required be sold off to raise some money for the university and to assist in the financial rationalization that was required to get a hold of the Government of Ontario's money. As I say, there's no hint in the case that this was anything other than a really, really serious problem. maybe not a full arterial hemorrhage, but not far off it. So the board, having got its report, decided to take the measures that I've referred to. The Senate was opposed. Others were opposed. It's fair to say that in a small p political sense, it was a big battle. And ultimately, as I say, these two faculty members, one of whom happened to be a senator, decided to take it on in court. And you'll see at the top of page 25, or sorry, page 7 at paragraph 25, the legal challenge to the board's decision invoked, among other matters, an allegation that Trent's Senate had to approve the consolidation reflected in the board's decision. As in UBC 2010, the result turned on the authority and powers allocated to the board and the Senate by Trent's constitutional statute. So here we have kind of the flip side of UBC 2010. Here we have the Senate saying, well, the board can't do that. We didn't quite have the Senate saying that in UBC 2010, obviously. It was the Faculty Association that was raising the issue. But I say it was the flip side of the coin because there it was the board's actions in entering into the collective agreement with the faculty that were being challenged as a matter outside the board's authority. And the Ontario Court of Appeal found that the statute conferred on the board the necessary power and authority to decide to consolidate Trent's operations and to sell the facilities made redundant by the consolidation. Ontario Court of Appeal noted the many, I put it in quotes, political arguments that had been made against the board's decision, but indicated at the end of the day those arguments were, in a legal sense, irrelevant. The central issue for the Ontario Court of Appeal was a legal one. Did the board have the authority to make the decision in issue, and if so, was that authority in any sense conditional on the Senate's involvement or approval? So it comes back to a point that I touched on early in my remarks, that the powers that are being wielded, the authority that is being exercised, is a product of the statute. It's not a political power in that sense. It's, at the end of the day, a legal power. And from the court's perspective, it either exists or it doesn't exist. If it exists, the political dimension doesn't matter. Similarly, if it doesn't exist, the political dimension doesn't matter. If the board has decided to do something and it's within its power and there are no preconditions, then at the end of the day, the board can do it. Similarly, the Senate, if it has the authority and it decides to do something, at the end of the day, it can do it. And the decision will be upheld or not, depending on the circumstances of the authority by the court. Now, a final case that I think it's worth touching on is the BC Court of Appeal's decision in another dispute between the University of British Columbia and its Faculty Association. This is UBC 2007, as I mentioned, and it's commonly known as the Rucker case. It involved a faculty member's application for promotion to full professor. He was a faculty member in the School of Dentistry and applied, as I say, to become a full professor. The promotion was ultimately not recommended by the president. As some of you may know, under the University Act, the president has to recommend a promotion before the board has the authority to give the promotion. And the Faculty Association challenged that decision on behalf of Dr. Rucker. The reason it ended up in court is that the arbitrator who was hearing the case decided that the word used in the faculty agreement, which was reverse, gave her the power to substitute her recommendation for the president's recommendation. So she interpreted the word reverse to mean if the president's made a negative recommendation, I can reverse that, I have that power, and I can turn it into a positive recommendation. UBC challenged that and said, no, you don't have that authority. And again, this is a fight between, not in a literal sense, but it's a fight between the powers of the board and in this case, the powers of the president. Because keep in mind, it's the president who has the statutory power to make the recommendation. So the Court of Appeal sets out in some detail, I won't go through the whole quote, in some detail the powers of the president as they are set out in the statute, and then sets out the powers of the board about halfway down page 8, and then at page 9 at paragraph 30, I comment on the decision the Court of Appeal reaches. Court of Appeal found that an arbitrator could not interpret the word reverse in the collective agreement to mean that she had the jurisdiction to substitute her recommendation for the president's recommendation. She could not so interpret the word reverse because the board, in the exercise of its power to enter into the faculty collective agreement, could not fetter or otherwise qualify a statutory power which had been expressly conferred on the president, and I quote from the decision. The association argues that the parties to the collective agreement were entitled to agree that the remedial provisions in the agreement would operate in the manner interpreted by the arbitrator, so as to grant an arbitrator the authority either to direct the president to exercise the statutory grant of power set out in the University Act in a particular way, or to bypass the grant of authority to the president by having the recommendation to the Board of Governors proceed as a deemed recommendation of the president, the process that the original panel described as not requiring the president to do anything. I would not give effect to that submission. I've appeared in the Court of Appeal, and I can tell you when a Court of Appeal judge says something like that, it's quite chilling. They're pretty remote, you know, there are 3 of them and they sit up there. The bench is actually a bit higher in the Court of Appeal than in the Supreme Court. It's like they've all got ice water for blood, you know, they're just there to resolve points of law. You can picture them kind of donning the black cap and, you know, sentencing somebody to death or something. It's pretty grim. So if a Court of Appeal judge says, I would not give effect to that submission, you're in trouble. The parties to the collective agreement could not agree to restrict or fetter in scope the president's exercise of statutory authority to reversal by an arbitrator. And any interpretation of the arbitrator's remedial authority pursuant to the collective agreement that allowed the arbitrator to reverse the president's decision on matters governed by the president's statutory grant of authority would constitute a direct interference with that statutory grant of power and would be incompatible and inconsistent with the statutory scheme. So it's just underlining in a slightly different context the point I've been at pains to make because it's the most critical point, and that is that where the statute confers power and authority, then the power and authority has to be exercised in conformity with and on the terms set out by the statute. And say, the critical concern today are the board's powers and even more the Senate's powers, but the principle holds elsewhere. The president, as many of you know or now have seen, has some specific powers under the statute, and indeed it's by statute that the president is chair of the Senate. And nobody, not the Senate, not the board, has the authority to trench or fetter those powers. So that principle is reciprocal. It exists throughout the statute. And as I say, Rucker provides, or UBC 27 as I'm calling it, provides another example of the application of that principle. Of course.
And so how could they have gone around this? Could they have said that it's in the collective agreement that the decision of the arbitrator would be a recommendation to the president, or that the president would agree to accept the decision of the arbitrator, or what could they have gone with this?
Yeah, it's a good question, and there are different formulations. One that exists at SFU, because the same problem arises when there's a termination of a faculty member, is that the president makes the recommendation, but the board submits its decision to arbitration. So that's how they get around it at SFU, for example. The president makes the recommendation, nobody touches that. It's a recommendation, not a decision. And so it's the board that makes the decision. And so the board says that under the faculty arrangements at SFU, we're referring our decision to the arbitrator, and so it's all battled out in front of the arbitrator. Another thing that can happen is that, and this is modeled a little bit after how judicial review works, is that the matter is referred back to the President from the arbitrator with not so much directions, that's what Supreme Court judges do when they're dealing with judicial review, but reasons as to what the problems were with the recommendation. So I'm going slightly by memory, but I think I'm right. In Rucker, the issue, as is so often the case, revolved around the caliber of the candidate's research record. The overwhelming majority of tenure and promotion disputes in which I've been involved, it's the research record where there's debate, unless it's a hopeless case, and then they don't tend to end up at hearing. And the argument of the Faculty Association in Rucker was that the various committees in the hierarchy had failed to consider Dr. Rucker's other types of work, and I don't remember the detail of that, but his other types of work focused overly narrowly on a traditional research model, and the President had not accepted the Faculty Association's position in that regard. The arbitrator disagreed with, it wasn't just the President who had that view, but the arbitrator disagreed with that view of it and said, oh, the broader record should have been considered. It could have been referred back to the President. Indeed, if memory serves, that's what happens in the Rucker case. It goes back to the President for reconsideration in light of the arbitral analysis. That analysis wouldn't bind the President, but obviously the President, if it was Martha Piper then, so if she continued to disagree, would have to have pretty good reasons and set those out in some detail. But that's another model, is it goes back to the President to be reconsidered. And so those are probably the two easiest ways that it could be dealt with. Does that answer the question? Now we're turning to a new topic, and it's an important one, so we're a touch ahead of when Gordon thought we might take a break, but I'm not going to suggest we take 10 minutes now before we come to the Senate's responsibility and powers. I know you'll all be quite keen on that. So maybe by my watch, about 5:15. And I'm happy if anyone's got any questions they didn't want to ask to chat a bit.